Welcome back to the courtroom. I'm Terry Darrell Caldwell. We have presented the case against racial classification. We have shown that the categories are incoherent, the machinery is administrative, the census reifies a fiction, the political symbiosis feeds on division, and the Caldwell model offers a precise alternative. Now we ask the final question: how do we get from here to there? The answer is not a gradual reform. It is not a compromise. It is a constitutional amendment. Amendment 28 to the United States Constitution. The prosecution will present the text, the rationale, and the implementation roadmap. This is not a petition. This is an execution order for a 4th-century-old lie. Let us begin. The full text of Amendment 28 is short. The prosecution will read it. Section 1. No person shall be classified, categorized, identified, or treated by any federal, state, or local government entity on the basis of race, color, ethnicity, or any derivative thereof for any purpose whatsoever, including but not limited to census enumeration, legislative apportionment, districting or redistricting, admission, hiring, promotion, or contracting, eligibility for public benefits, grants, loans, or contracts, data collection, reporting, or analysis, in any form of preferential treatment, remedy, or penalty. Section 2. All existing federal, state, and local laws, regulations, policies, forms, databases, and practices that classify, categorize, or identify persons by race, color, ethnicity, or any derivative thereof are hereby declared null and void and shall be repealed, amended, or eliminated within 5 years of ratification. Section 3. Congress shall have the power to enforce this article by appropriate legislation. The prosecution notes 3 features. Number 1, the prohibition is absolute. No government entity may classify by race for any purpose. No exceptions for benign classification. No exceptions for data collection. The state is out of the race business entirely. Number 2, the transition is 5 years. Agencies have time to redesign forms, retrain staff, and implement alternatives. After 5 years, the remaining race-based laws are automatically null and void. Number 3, Congress has enforcement power. The amendment does not leave abolition to the courts alone. Congress can pass legislation to enforce it. The prosecution submits that this is not radical. It is the logical conclusion of the 14th Amendment's Equal Protection Clause. If the state cannot discriminate on the basis of race, it should not be able to classify on the basis of race. The current Constitution does not explicitly mandate racial classification, but it also does not forbid it. The Supreme Court has held that racial classifications are subject to strict scrutiny. They are presumptively invalid, but can survive if narrowly tailored to a compelling interest. The problem is that the court has never applied strict scrutiny to the classification system itself. It has only applied it to specific uses of race: affirmative action, redistricting, set-asides. The result is a patchwork. Race is forbidden in some contexts and required in others. The Voting Rights Act requires majority-minority districts. The NIH mandates race-based clinical trial reporting. The census demands race boxes. The Constitution does not require any of this. Congress has never defined race. The categories are administrative. The courts have never upheld the system as a whole. Amendment 28 closes the gap. It says, no government entity shall classify by race for any purpose, period. No strict scrutiny balancing tests. No exceptions for well-intentioned uses. The prosecution submits that this is not a restriction on liberty. It is an expansion of liberty. It frees citizens from the obligation to declare their race to the state. The prosecution acknowledges a legitimate concern: the unique political status of federally recognized Indian tribes. Section 4 of the amendment, which the prosecution has not yet read, addresses this. Nothing in this article shall be construed to prohibit any federally recognized Indian tribe from determining its own citizenship, enrollment, or membership criteria in accordance with its sovereign authority. In other words, tribes may still define their own citizens. The federal government may still fulfill its trust responsibilities, but the federal government may not use Native American as a race proxy for general purpose policies. The prosecution supports this carve-out. Tribal citizenship is political, not racial. A tribe is a sovereign nation, not a race. The amendment respects that distinction. The prosecution notes that the current system does not respect it. The census race box conflates tribal citizenship with biological ancestry. Amendment 28 corrects that error. The prosecution has been asked, is 5 years enough? The answer is yes. The transition is phased. Year 1, OMB rescinds Directive 15. Federal agencies submit transition plans. Congress begins amending race-based statutes, Voting Rights Act, NIH Revitalization Act, etc. Year 2, new forms are designed. Pilot programs in selected states test the Caldwell Model's variables, income, geography, ancestry. Year 3, the 2030 census is designed. Without race boxes, agencies begin implementing the new framework. Year 4, the Supreme Court, if necessary, resolves challenges. The transition continues. Year 5, all remaining race-based laws, regulations, and practices are null and void. The classification system is dead. The prosecution does not claim this will be easy. But the current system was built over decades. It can be dismantled in 5 years. We have discussed Nazi racial classification. The Nazis did not invent race. They inherited a system of classification that had been built over centuries. They weaponized it. The prosecution is not comparing the United States to Nazi Germany. The point is different. Once a classification system exists, it can be used by anyone who seizes power. The current American system is a tool. Today, it is used for benign purposes, funding, enforcement, representation. Tomorrow, it could be used for something else. The same data that funds a community center can be used to target that community for surveillance. The only way to prevent the misuse of racial classification is to abolish the classification itself, not reform it, not add more boxes, not trust that the right people will be in charge. Amendment 28 is not a partisan document. It does not favor left or right. It removes the weapon from the table entirely. Now, the prosecution asked the jury to consider a final question. If the racial classification system is scientifically invalid, administratively arbitrary, politically exploited, and potentially dangerous, if the Constitution does not require it and the courts have not upheld it, if the alternative, the Caldwell model, is more precise and effective, then on what grounds do we delay abolition? The answer is not evidence. It is fear. Fear of change, fear of the unknown, fear of losing the categories that have structured American politics for generations. The prosecution does not dismiss this fear. Change is hard, but the cost of inaction is higher. Every year that the system persists, millions of Americans are forced to check boxes that do not represent them. Every year, disparities are managed, not remedied. Every year, the left-right symbiosis feeds on division. The present is the cheapest moment to act. In our final episode, episode 13, we will look beyond the amendment. We will examine the Zodiac Protocol, the mythic narrative that envisions what a post-racial America could look like. We will end not with a legal argument, but with a glimpse of the future. But for today, the prosecution rests on count 12. Amendment 28 is not a petition. It is a constitutional execution order. It is the kill box we promised in episode 1. The text is written, the roadmap is mapped, the alternative is ready. The only remaining question is whether we have the will. The case against race has been presented. The evidence has been entered into the record. The jury is you. Court will reconvene for one final session, the Zodiac Protocol, a post-racial vision.